Paterson, you have the call. We're going to a break at 9, so you'll take us through to there.
I have questions about the NZYQ cohort and in particular about the community safety orders. Ms Sharp, I suspect this will be one for you. How many community safety orders has the Minister for Home Affairs applied for?
Senator, no community safety orders have been applied for yet.
Right. So you will remember the many times we've discussed this issue in the past, most recently in November 2024, in which you said, and I quote, "We anticipate the Minister will apply for the first order in the coming weeks." That was 16 weeks ago. What is the hold-up for the first application?
One of the most challenging aspects of putting together these cases is how fluid the cases themselves are, as in the people are in the community and their facts are constantly changing around you. So I believe what I said at, you didn't ask to put this to me, but I do believe what I said at that hearing was true. To the best of my knowledge at that point in time,
I'm sure it was. I'm not suggesting otherwise.
But the facts change, and these cases are some really complex confluence of mental health and criminal offending, and so the case was delayed. Well, the case, those front runner ones have been delayed a bit. Getting them once we kind of re-establish facts. We then need to collate the evidence because of the exculpatory evidentiary requirement. We then need to make sure we've got completely up-to-date records and sometimes send them back round to the expert again. It's hard to overstate how painstaking the process of putting one of these applications together is.
Sure. As you know, and as I put to you previously, it's not the first time that someone has said that an application was imminent. The former Minister for Immigration, Mr Giles, in May 2024, said that there were 6 cases before the expert review stage, which is the last stage before a matter can go to court for a court to make an order of preventive detention. And he said there were 26 in an advanced stage of preparation. I mean, that was May. We're not far away from a year on from when that statement was made. Do you think the Minister misled the public with that statement?
The only thing I would say, and I think we've brought to this committee's attention before, that in the sister scheme, in the high-risk terrorism offenders scheme, it took over 3 years to put together the first application. I think we threw everything we could at doing this as fast, and we were ambitious. I think the longer we're rolling this out, the more we're getting to understand that 3 years and why it did take so long.
And so Mr Giles' evidence, Senator, was correct. Not his evidence, his statements were correct in that there were a number of cases that were at the expert review stage. There were many more which were at an advanced stage, by which he meant for which we had sent out and were processing all of the requests for information relating to those cases. What we didn't know at that time was what Ms Sharp has just explained to you, just how challenging it would be for us to pull all of that together.
So the Minister for Home Affairs on the 16th of February said there are no cases for preventive detention that are nearly ready to go. Is that statement correct?
The threshold for preventative detention is really high. So when I've been talking about orders with you, I have been talking about both types in my mind, both types of orders. He was correct that there are no cases that I'm aware of that are very close to being filed that relate to preventative detention. The ones that are more advanced do relate to community supervision orders.
So we've gone in May 24 from 6 that were almost ready and 26 at an advanced stage to November, when you said there was 1, and now in February there are 0. It seems like we're going backwards, not forwards, in the time that's elapsed. How can the public have any confidence that these powers are ever going to be used given that trajectory?
So if I could just, for clarity, Senator, note that Minister Giles' statement referred not specifically to detention orders but to the scheme overall. And I think we've just explained the...
Actually, no, he did say preventive detention specifically in his quote. let me quote, which is the last stage before a matter can go to a court for a court to make an order of preventive detention.
Senator,
You're not responsible for the former minister, who is no longer the minister for a good reason, but, I mean, the public is entitled to rely on statements made by ministers and the government about this, and it seems like we're getting further away, not closer, from these powers being used.
so Senator, I would only say that the terminology, the complexity of this is such that it may well have been that the minister meant the scheme more generally, because it's difficult for us at the stage of collating the information and going to experts to determine whether it would be a detention order or a supervision order that we were seeking.
How much staff hours have been spent on preparing these cases over the last 15 or 16 months since the legislation was passed?
We've had a task force established since I guess the first staff went into it immediately after the legislation passed in December 2023, and we've had a task force staffed ever since.
And you've given evidence previously about how many people are in that team, but it's quite a large number.
Yeah. Yes.
How many?
There are currently 45 staff in it.
Right, so let's not assume they've all been there that whole time, but 45 staff working for up to 15 months and nothing to show for it?
I think that depends on how you define nothing to show for it.
Well, I would define it as actions that have protected the community.
So we have a much deeper knowledge of the offending profile of those, and we've gathered up a lot more intelligence about the community safety risk posed by individuals that we're prioritising through this.
But this legislation wasn't passed for an intelligence collection purpose. It was passed to remove people who are dangerous in the community out of the community, and that hasn't happened.
It certainly imposes very strict requirements on those who are tasked with implementing it to gather up a very detailed amount of knowledge, and only to file an application if it's in the case of detention where there's a high degree of probability on the basis of admissible evidence that there is no other less restrictive measure available that would prevent the person's risk to the community.
What I'm getting at is given all the time and resources and effort that's gone to this without a single CSO or detention order being applied for, should at some point over that year we thought, is further legislative amendment necessary to make this process easier? Like, the Parliament's been sitting, if this bar is so high, couldn't the bar have been lowered to make the task of your team easier?
Senator, I think as I described before, this has been a process of us understanding and learning what we need to do to get to the point where we can lodge an application. And to pick up Ms Sharp's point, that work will not be wasted when we get to a point where we're able to lodge such an application.
Give me confidence that we're going to arrive at that at some point, because every time I ask about this, I'm told it's not too far away, progress has been made, and every time we return to this, it doesn't appear like any progress has been made. I don't want to diminish the work of the team. I'm sure they're very diligently applying themselves, but from the public's point of view, there's, I think, 279 of this cohort out of detention at the moment at the last update. None of them have been preventively detained.
Just another factor that makes this scheme, I mean, I've told you about a lot of the challenges of the scheme, but just one further one is the existence, side by side with the bridging visa, are visa conditions. So unlike the high-risk terrorism offenders scheme, we have to be able to demonstrate that a community safety supervision order, for example, is needed even though the person has electronic monitoring and curfew applied to them. And then we need to show that those two things are not sufficient. So it just makes the leap that bit higher, because we have to show that those things,
even with those things,
there's still an unacceptable community safety risk that we need to manage.
With indulgence, Chair. Just from a legal point of view, in terms of managing the issue, you've had this task force working on this diligently, and as Senator Patterson said, I'm sure they are working diligently. At some point in time, have you circle the wagons, if I can put it that way, considered where you're up to, and considered whether or not you should simply lodge an application and test the law and see what the result of that is. Because at least at that stage, you'd perhaps get a better sense from the courts as to whether or not you're meeting the relevant evidential boundaries or not, and that could inform potentially an amendment of legislation, because it just seems to me it's a long period of time, Secretary, and I guess I'm directing the question to you, Secretary, in terms of taking a helicopter view of this process. Have you given thought to that?
So, Senator, we have given thought to where's the sweet spot, if I can put it that way, between lodging and testing and actually meeting all of our obligations to lodge, and an understandable desire for us to build a successful case, to test the provisions successfully. We're also very conscious, and I know that the circumstances of the cohorts are different, but we're also really conscious of the time it took to build the first cases in the Harto scheme, which arguably are a little more straightforward in terms of the nature of the offences that were being considered. And so, yes, it feels like a long time, and I'm sure it feels like a long time to the team involved in it as well.
Well, it is a long time.
But when we compare it to the 3 years that it took to lodge the first Harto case, that gives us some perspective on what we're trying to achieve.
I hope it's not going to take 3 years to lodge the first preventative detention order. I mean, the key difference between the Harto scheme and this scheme is that those people are already detained. They're serving custodial sentences for terrorism offences, and it's a continuing detention order to keep them behind bars, whereas this is a preventative detention order to get these people off the streets. And I don't think the public will think this has been a good return on investment for the however many millions of dollars of staff hours that would have gone into this. I ask again, Ms Sharp, is there any amendments that the Parliament could make to this legislation to make the task of your team easier in meeting this threshold?
Senator, as you know, the scheme is modelled on the high-risk terrorism offender scheme, because that's the model that the Harto scheme has been tested in the High Court and has been found to be constitutional. Whether there's any amendments that can be made, our assessment is any amendments that you would be making to, for example, reduce the thresholds or reduce the evidentiary burden on the Commonwealth would necessarily increase the constitutional risk. So that would be a matter for government to make that choice. If it wanted to try and redesign and cut the thresholds and increase constitutional risk.
I think we've seen, Senator Patterson, what happens when politicians get involved and start writing legislation with disregard for constitutional risk. Mr Dutton did that a number of times, and that legislation has been thrown out by the High Court.
Minister, legislation which you brought through the Senate has been thrown out by the High Court.
We are here having this discussion because of legislation
without sin cast the
Mr.
first
Dutton put in.
stone, Minister.
And maybe this is the point at which I remind you that when Mr Dutton was the Home Affairs Minister, he released 102 convicted sex offenders from detention.
You gave me a personal...
No monitoring, electronic or otherwise.
Minister, you gave me
a
personal
opposition.
assurance in the Senate when I asked you when a previous iteration of the visa legislation for the NZYQ cohort was sound, and you said it was, and it was subsequently struck down by the High Court, so we can all play that game. Let me ask you, Minister, is it satisfactory to the government that 15 months on from this legislation passing, it has not been used once?
It's satisfactory to the government that the department is doing everything they can to seek these orders in a way that are going to hold up in court. It's no more satisfactory that Mr Dutton released 102 convicted sex offenders from detention when he was the minister, but you never seem to want to talk about that, with no monitoring whatsoever.
We are going to a break in a minute.
Thanks, Chair.
Thanks. The committee is going to suspend for 15 minutes.